Welcome to the Littleton Chambers podcast.
Afternoon, everyone. I can see that the clock has just ticked over to 12:30, so we'll make a start. And thanks for joining Tim, Sophie, and me for the latest in the Littleton series of seminars exploring different aspects of the Employment Rights Act 2025. And the specific bit that we're putting under the microscope today is Section 28. And of course, you won't be citing Section 28, once it's implemented, you'll be citing the new bits of the Employment Rights Act 1996, which it introduces, specifically sections 104I, J, and K. And these new provisions have been referred to almost universally as the reforms addressing fire and rehire and fire and replace. And that is perhaps, well, that label is perhaps forgivable because the policy objective of what would become Section 28 of Era 25 was contained within the original government paper entitled Next Steps to Make Work Pay that was published on the 10th of October of 2024. And it announced that the government would abolish, quote, the scourge of fire and rehire, which it described as a component of one-sided flexibility in the relationship between employers and employees. And the government would do this by, quote, closing the loopholes which allow firms to engage in these unscrupulous practices. The Employment Rights Bill, as it then was, reforms the law to provide effective remedies to stop these practices, whilst also maintaining that businesses can restructure to remain viable, preserve their workforce and the company when there is genuinely no alternative. And over the course of this session, the one takeaway I want you to have is that the label fire and rehire gives a misleadingly narrow description of the reforms, because the reforms, in fact, go much further than that in policing changes to terms and conditions of employment. And as a sort of prelude for some of the issues that we'll discuss in this session, I'm going to compare the perceived problem with the proposed solution. So let us transport ourselves back to the 17th of March of 2022. For those interested, Dave was at number 1 in the charts with his single Starlight, but perhaps more relevantly for today's purposes, the DP World-owned P&O sacked 786 seafarers over Zoom and replaced them with agency workers on roughly £5.50 an hour. Now, if you're sat there wondering how they could pay significantly less than the national minimum wage, it's because the new employees were regarded as seafarers who fell outside of the territorial scope of the national minimum wage legislation. Now, why was P&O a scandal? Well, it wasn't just the scale of the termination exercise and the cynicism with which it was undertaken. It was also the fact that P&O knew that what they were doing was in breach of their legal obligations, but they did it anyway, thinking that it was the better option for them. And they were largely vindicated in that approach because despite the large amounts of righteous indignation that followed, the company escaped prosecution. So, for example, the Insolvency Service declined to bring proceedings for the notification offence, so the failure to file an HR1. Under Section 194 of TULRECA, the director's disqualification route went nowhere. The chief executive, Peter Hebblethwaite, did a few mea culpas before various select committees but remained in post. And there weren't even any tribunal claims because they were all settled. So what were the key features of the problem? So it seems to me that they were these. Firstly, mass terminations of employees for an unfair commercial advantage. And secondly, a lack of effective enforcement of penalties against the apparent wrongdoer. But was the problem a lack of redress for the employees? Because who seriously thinks that those claims wouldn't have been successful had they been pursued? And ultimately, their settlement was a question of choice by the employees in question in the same way as the settlement of any other legal claim. And as we go through today's session, I want you to keep in mind the perceived problem so that you can mentally contrast it with the proposed solution. And it may bring to mind the old adage, often trotted out in cases, and may be applicable here, that hard cases make bad law. So with that introduction out of the way, it brings me on to my co-presenters. We have Tim Goodwin, who will set out the law as it currently stands on dismissal and re-engagement, and then move on to set out the bones of the new statutory provisions. We also have Sophie Cashell, who will look at restricted variations and identify the key questions in how the new unfair dismissal right will operate in practice. And then I will swoop back in at the end and look at unilateral variation clauses. And you may well be sat there thinking, well, how does that somewhat obscure bit of employment law fit into all of this? Well, there is at least an argument to say that they sidestep the whole regime, and why that may be, I will discuss later. So hopefully there will be some time for questions at the end. So if you want to put up your virtual hands at the end of the session to ask your questions, you can. I think the way the webinar setup is that you have to type your questions into the chat box, but we will have a look at that chat box at the end and pick out all the questions we think we can answer and studiously ignore the ones we think we can't answer. But having said that, I will pass over to Tim, who will look at the current law. Thanks very much.
Thank you, Dan. So yes, it falls to me to look at what the state of fire and rehire law is as it currently stands, and then we'll have a look at what's coming into force from the 1st of January next year. The issue of fire and rehire is, I think it's fair to say in the majority of cases, something of an issue of last resort. It tends to come about after the employer has taken steps to agree new contracts, perhaps just a contract variation. Those steps have gone nowhere. There's usually been some sort of consultation. There may have been some compromise of shifting a position, but it has been unsuccessful. And ultimately, to achieve the variation the employer wants, the employer will have to dismiss the employee and offer to immediately re-employ them on the new varied terms. Now, generally, there's no contractual issue with that, provided that sufficient notice is given. And that brings me to the first of three caveats to there being no contractual issue. Notice itself can be something of a bear trap, given that different employees may have different notice periods. Some employees may be entitled to more notice than their contract suggests, if it's statutory notice. Sometimes the employer may want or even need to bring in the change before the notice period expires. The second caveat to the issue of contractual issues is that in pretty rare circumstances, historic promises and undertakings can imply an effective prohibition on this sort of dismissal. And in Usdaw and Tesco, a 2024 case, the employer in that case had promised to retain a benefit for life and described it as permanent and elsewhere as guaranteed. So when the supermarket then sought to remove that benefit, the union brought injunctive proceedings, which were granted by the High Court and ultimately upheld by the Supreme Court, concluding that the employer's historic promises amounted to an implied term that it would not use fire and rehire to impose changes that would remove those guaranteed benefits. And then finally, there is a risk, I think it is just a risk, that the mere threat of deploying fire and rehire could amount to a repudiation breach of contract and therefore give rise to a constructive dismissal in and of itself. That was the view taken by the EAT in Greenaway, Harrison and Wiles. But it wasn't the view taken by the EAT some years later in Kerry, Foods and Lynch. In that case, the EAT held that because the lawful serving of notice under a contract is not a breach of contract and couldn't be, serving lawful notice couldn't be a breach of the duty of trust and confidence. The threat to do that, the threat to do something lawful and permitted under the contract, cannot in and of itself amount to a breach of the duty of trust and confidence. So we're left on that point with a bit of a contradictory position and contradictory decisions from the EAT. In practical terms, I think the best we can say is that threatening to deploy fire and rehire is not without risk, although my view is that the decision reached by the EAT in Kerry and Lynch is perhaps the more more persuasive decision. Either way, if fire and rehire is deployed, there's going to be a dismissal. And if there is a dismissal, and if the employee has sufficient service, there will then be grounds for an unfair dismissal claim. That then engages the question of whether there's a fair reason for dismissal. In most cases, the employer is going to plead some other substantial reason. It's well established that if the employer has a sound business reason for dismissing an employee that doesn't accept a contractual variation, this will amount to some other substantial reason and therefore a potentially fair reason. What is a sound business reason? Well, it is a business reason that a reasonable employer would consider sound, which feels a little bit circular. But the point is, it's not one that the actual employer subjectively considers sound, nor is it one that the tribunal, substituting its own view, considers sound. So you can see how it is, in a sense, akin to the range of reasonable responses test. It is what would a reasonable employer consider a sound reason. It does not need to be the contractual variation you're looking to impose does not need to be one that is crucial to the survival of the business. Whilst at one point it was thought that the employer would need to show that it was under some special pressure to make the change, that principle too has now been roundly rejected. Nor does it make any difference, at least in terms of the fairness of the reason for dismissal, whether the employee's refusal of the variation was reasonable. Although that is something we will revisit later. There is also, of course, the possibility that the variation may be required, may come about through a redundancy situation, where, for example, you might be merging two roles into one and need to make variations to the contract to that effect. And of course, if that is the case, redundancy or dealing with it as a redundancy situation may be the sensible way forward. I turn then to the overall fairness of the dismissal. An employer who dismisses on the spot is unlikely to be able to show that the dismissal was fair. Conversely, an employer who consults with the employee for whom it is trying to vary the contract is more likely to be able to defend the claim. As I said at the outset, in most cases, fire and rehire doesn't come out of the blue. Seldom the first port of call. I think P&O varies obviously is a very substantially different situation. In most cases, there has already been some discussion, some consultation on the variation or on the new contract. And fire and rehire is turned to as a last resort. And so in those sorts of cases, employers will almost certainly already have consulted fairly extensively before they reach for the dismissal. Ultimately, the question of reasonableness is a balancing act that the tribunal has to strike. That was confirmed in Catamaran Cruises, the reference for which is on the previous slide. The tribunal has to consider all the factors, all the relevant factors, and determine whether the decision to dismiss fell into that infamous range of reasonable responses. And then, just before wrapping up on this part, there is the issue of mitigation. The point is, can it be said that the employee who offered a new contract, who was dismissed, offered a new contract, offered a varied contract, fails to accept that, has failed to mitigate the loss? Technically, yes, that's certainly arguable. It's an argument we run in these sorts of cases all the time. But it should come with a bit of a health warning. Let's take a step back. Let's remind ourselves what is the duty to mitigate. And it is a duty to take reasonable steps to mitigate one's loss. And the burden of proving a failure to mitigate falls not on the employee. It's not that the employee must prove they have taken those reasonable steps. It is on the employer to show that the employee has acted unreasonably. So when we get to mitigation, the question of whether the employee's reasonableness in refusing the offer of new employment or refusing the variation really does kick in. It would, in my view, be an error of law for a tribunal to find that a reasonable refusal of re-employment amounted to an unreasonable failure to mitigate. Just before I move on from the current law, I just want to make reference to one thing, and that is the Statutory Code of Practice on Dismissal and Re-engagement. That came into effect in July 2024, provides a mechanism for compensation to be uplifted by up to 25% for an unreasonable failure to comply with the code. So it's much like the ACAS code on adjustment. That then is an ever so brief overview of the law as it currently stands. I'm now going to turn to what are we going to see coming by way of the Employment Rights Act 2025. Section 28 of the 2025 Act will create 3 new sections of the Employment Rights Act 1996. That's simply titled 104I, 104J, and 104K. Section 104I is going to create a new species of automatic unfair dismissal, where the reason or principal reason for the dismissal is either that an individual did not agree to the employer's requested variation of contract, or where the reasonable or principal reason for dismissal is to enable the employer to engage another person or re-engage the same employee under a varied contract of employment. In either case, the principal is not engaged unless the variation that is proposed is a restricted variation. Subsection 5 of the new 104I will contain a list of restricted variations, and they're the sorts of things you would expect to see engaged and prohibited. They go to terms such as remuneration, time off, working hours. Sophie is going to cover those in more detail, so I shall say no more. But the fact that the variation or proposed variation is not a restricted variation doesn't give employers carte blanche to impose it. That's where Section 104J comes in. Section 104J, this doesn't create a new type of automatic unfair dismissal, but it provides that where the reason or principal reason for the dismissal is the proposed variation, but the variations were not restricted variations, then when it comes to assessing the issue of fairness in an unfair dismissal claim, there are now a range of statutory factors the tribunal will have to take into account, and they include the reason for the variation, the consultations carried out, whether with the individual or the trade union, anything offered in exchange for the variation, and anything deemed relevant by the Secretary of State by way of new regulations that we have yet to see. And then finally, we come on to Section 104K, and that deals effectively with outsourcing. Now, this will create yet another new type of automatic unfair dismissal, and that is where an employer replaces an employee with someone who is not an employee. So there are 3 conditions that have to be met to bring your Section 104K automatic unfair dismissal. Firstly, the replacement has to carry out activities for the purposes of the employer's business. The activities, secondly, the replacement carries out the activities are the same or substantially the same as those carried out by the employee pre-dismissal. And then thirdly, the employee's dismissal is not wholly or mainly attributable to those activities having ceased or diminished. And of course, that last condition sounds an awful lot like one of the definitions of redundancy at Section 139 of the 96 Act. There could, though, be circumstances where a situation that is an entirely valid redundancy will nevertheless amount to an automatic unfair dismissal under 104K. So, for example, if you have someone doing a role within your business and you decide to outsource that function will continue to be done. And as a result of the outsourcing, in most cases, that will amount to a redundancy under Section 139. But if the activities that the outsourced person is going to be doing, if they remain broadly the same as the employee was doing pre-dismissal, and that person carrying them out is, for example, a self-employed contractor, then the dismissed employee will have been automatically unfairly dismissed, notwithstanding that there was a perfectly valid redundancy situation. So that is a rattle through of the new provisions that you will see coming into force from the 1st of January. I'll hand over to Sophie to go into a little bit more detail.
Thank you very much, Tim, and good afternoon, everyone. Thank you for joining us today. As Dan mentioned at the start, broadly speaking, I'm going to be discussing two topics today. Firstly, looking at restricted variations and the consultation that took place recently. I say recently, I think it was back in April, so perhaps not so recently. And secondly, some practical considerations, including potential defences when we are considering changes brought about by Section 28 of the Employment Rights Act 2025. Now, I have the enviable position as well of moving the slides along, so I am hoping that everyone can see those slides. And if you can't, please do put that in the chat, but I'm going to go ahead assuming everyone can see them. So starting with restricted variations. As Tim has mentioned, the reforms contain a crucial distinction in respect of variations. Section 104I has a new cause of action, automatic unfair dismissal, in relation to restricted variations. Section 104J has ordinary unfair dismissal with some additional heightened mandatory considerations, where the variations are not restricted variations. Obviously, then, given this distinction and its importance in relation to the type of claims, but also the defences potentially available, the key question is, well, what is a restricted variation? Now, the happy news is that Section 28 has introduced a list of restricted variations in Section 104I, subsection 5. I think this talk does need somewhat a health warning in relation to the amount of letters and alphabet letters and numbers that are going to be used, because there's an awful lot of subsections that I am going to be referring to. So forgive me in advance for doing so. But in relation to the restricted variations, those are set out, they're defined in section 104I5, which hopefully you can see on the screen there. I am not going to read out all of that text, but it is there for your information. Now, the unhappy or happy news, I suppose, depending on who you represent, is that these subsections, broadly speaking, as Tim mentioned, encompass the core terms of an individual's employment contract. So subsections A to C deal with remuneration, with pay and pension. Subsections D and E, broadly speaking, deal with hours, so working hours, shift patterns. Subsection F deals with holidays, and subsection H, which is an important one when Dan comes on to his topic later, is an anti-avoidance section. So it prohibits the inclusion in a contract of employment of a term enabling an employer to make a variation without the employee's agreement when that variation amounts to a restricted variation. So those are the prohibited restricted variations as currently proposed. You'll see subsection G has a provision for the Secretary of State to include categories, but I understand from the consultation documents that nothing is presently set out to expand these. And I suppose, despite the fact I said, largely speaking, it encompasses the core terms of the employment contract, it is worth noting that in this section, it does not include place of work or an individual's duties. So those two aspects are not defined in restricted variations, albeit would be within the non-restricted variation section. Now, this is as it currently stands, but what we had back in February was a government consultation in relation to two potential restricted variations, in relation to employment expenses and benefit in kind, and in relation to shift patterns. The consultation ended back in April, as I said earlier, and the idea ultimately is in respect of these two aspects. The government is seeking to strike a balance between the protection of employees from significant detrimental changes to the terms and conditions of their employment, and as against the legitimate interests of businesses adapting to operational needs and the need for flexibility. So in this consultation, as I said, they looked at two potential restricted variations. The first was expenses and benefit or payment in kind. Now, this is in respect of section 104I5 subsection A, because as you will potentially see on the screen, it prohibits a reduction of or removal of an entitlement to any sum payable to an employee in connection with the employment. So that's quite a broad subsection. And what it currently includes as it's drafted is contractual expenses such as free lunch, or it includes participation in share schemes, travel expenses, accommodation, the like. So the government is consulting on whether there should be exclusions in relation to that subsection to exclude expenses and benefit or payment in kind. The two options presented is exempting it in full, which is the preferred option currently, or exempting all expenses, benefits of payment in kind, apart from certain types of share schemes, travel expenses, accommodation, with the rationale being that because those are benefits which are equivalent to pay and therefore important and significant in terms of salary and remuneration to those employees. Now, that's in relation to one of the restricted variations, and that's being consulted on. The second aspect I mentioned is shift patterns. And I think there's a recognition that shift patterns is a difficult matter to legislate against, because changing shift patterns can assist employees. There can be legitimate operational needs, the need to harmonise or to change and be flexible in relation to shift patterns, difficulty in explaining shift patterns, and etc. And so there's question of whether, in relation to, you'll see subsection E, it's prohibited a variation of the timing or duration of a shift which meets such conditions as may be specified in regulations made by the Secretary of State. So there's a recognition that whether a shift pattern or a type of shift pattern is or isn't prohibited as a restricted variation can be determined by the government, and that's what they're consulting on. Now, the two main options is firstly exempted in totality, so no shift pattern changes would be within the scope of restricted variation. That is not the preferred option. Instead, the preferred option is that only shift changes from day to night working and weekday to weekend working would fall within the scope of a restricted variation. So increasing the scope of some additional hours, adding a few hours at the end of the day, provided it doesn't turn into that day to night working, would not be a restricted variation, albeit it would no doubt fall into the non-restricted variation. So those are the two aspects that are being were consulted upon. We are still, and I again looked on the website today, we're still waiting the outcome. It says that they are analysing the feedback and to visit the page soon to download the outcomes. So we may be refreshing that page for a little while yet to see how that shapes up. But broadly speaking, those are the restricted variations as they stand. Now, I did say I would forget to, given I'm in charge of the slides, forget to move on my own slides. But what I will now talk about is where that leaves us in terms of practical considerations. So we've talked about what the changes under Section 28 are in terms of the provisions that's going to import into the Employment Rights Act 1996. And I'm sure a question on many people's lips is, well, how should we be advising when a fire and rehire situation occurs? What types of defences do we have when claims, either ordinary or automatic unfair dismissal claims, are brought in respect of these provisions when they're ultimately in force? Now, I have come up with 10 key questions which I consider to be relevant. And I'm briefly going to go through them to the extent I can be brief. So the first one, and forgive me for stating the obvious, I think in respect of the first three, these are slightly obvious questions, but no less important to ask, is firstly, are they an employee? To start with, the obvious, we are discussing employment dismissal rights. So the ordinary arguments for ordinary unfair dismissal, surrounding whether the individual satisfies the definition within Section 231 of the Employment Rights Act and whether they're working under a contract of employment will still be relevant to these types of claims or situations. The second question, do they have the requisite service? Again, perhaps an obvious point, and perhaps with the reduction from 2 years to 6 months, as of, I believe, the implementation of that will be the same time as the Rehire, fire and Rehire provisions. So from the beginning of 2027, perhaps that won't be as much of an issue, but nonetheless worth keeping in mind. Naturally, that will apply to the non-restricted variation provisions, so a complaint of ordinary unfair dismissal, as the service period will be exempt in respect of the automatic unfair dismissal causes of action under Section 104I and K. The third question is, well, was there a dismissal? Again, perhaps an obvious question to ask, but the provisions will only bite where there is, in fact, a dismissal. And Section 28 does not include a separate definition of dismissal for these purposes. So we rely again on Section 95(1) of the Employment Rights Act, and it will include contexts like a constructive dismissal, but also a Hogg and Dover College style dismissal where an employee continues to work under the new terms under protest. So any arguments about whether the employee was in fact dismissed within the meaning of the statute will remain a relevant defence or a relevant consideration in respect of any complaints brought in the context of fire and rehire. Number 4, were the variations contractual? So Section 104I and 104J, which deal with restricted and non-restricted variations, putting aside Section 104K, only apply to variations to the contract of employment. And so changes to the rights and obligations won't fall within the ambit of the legislation if they were non-contractual, an important distinction to keep in mind. Number 5, was there a failure to agree to the proposed contractual variations? Now, for those of you who have read the lengthy subsections that we are referring to, both subsection 104I2 and 104J2 only apply where there has been a variation, whether that's restricted or non-restricted, and the employee did not agree to that variation. So it only bites where there was a failure to agree. Now, there's also a prohibited reason in subsection 3 in relation to variations, but practically speaking, the context of these disputes will ordinarily arise when representatives or employees have not agreed to a change and therefore the contract is terminated. So naturally, a first question is, well, was there a failure to agree? If not, these potentially don't bite. That links to my 6th question, which is whether the agreement to the variation was required to affect the contractual change. Now, I'm not going to touch upon this in great detail because Dan is going to deal with unilateral variation clauses. But the short point is, if there was no agreement required, then arguably these provisions don't apply, because how can you fail to agree to something that you weren't required to agree to? The 7th question is, well, was there a restricted or non-restricted variation? I've obviously already, in the first part of this discussion, touched upon the importance of the distinction between restricted variation or non-restricted variation. For those of you that had dozed off or joined lately, a restricted variation will render a dismissal automatically unfair unless certain defences are applicable. But if it isn't a restricted variation, then there are still mandatory considerations to the ordinary unfair dismissal complaint. So whether there is a restricted or non-restricted variation, as I already mentioned, is important because different considerations set out in the different subsections then apply. Number 8, what was the reason or principal reason for the dismissal? As Tim touched upon, subsections 104I and 104K deals with various prohibited reasons in respect of restricted variations, non-restricted variations, and outsourcing. And so naturally, in order for the dismissal to fall within one of those sections, then the reasons need to be one of those as set out and prohibited there. If it's more than one reason, then there'll be a fight, no doubt, over what the principal reason was. Was the dismissal the restricted variation? Was the dismissal because they needed to employ another person under a varied contract to carry out the same or substantially same duties? Or was it something else? These are all factual questions that will be important to determine whether these subsections, these sections, do in fact bite. Now, number one, and arguably one of the most important in respect of the automatic unfair dismissal provisions of section 104I and K, is what is the financial position of the employer? Because in relation to these provisions, the presumption of automatic unfairness can be displaced if the employer can show that the reason for the variation or the reason for the outsourcing was due to the employer's financial difficulty. Now, I should caveat that the subsections do go into a little more detail. It's not as simple as that, but it's linked to an employer's financial difficulty. If that condition as set out in the subsections is satisfied, then the dismissal will not be automatically unfair, but the tribunal is still required to assess certain conditions on whether the dismissal was fair in all circumstances. And this defence in relation to the financial difficulties slightly differs depending on who the employing entity is. So if it's in the public sector or local authorities or any other employer, there are slightly different considerations. Now, in relation to general employers, this is in section 104I, subsection 8, and that is where the reason was to eliminate, prevent, or significantly reduce or mitigate effective financial difficulties. And in all the circumstances, the employer could not reasonably have avoided the need to make the restricted variation. There's two parts to it. Now, in respect of public sector and local authorities, similar provisions apply in terms of the considerations. However, in respect of that second part, whether they could reasonably have avoided the need to make the restricted variation, there are now judicial review principles imported. So the tribunal may need to consider concepts such as Wednesbury unreasonableness or illegality or other procedural failings. So there's certain concepts that will now be imported into that consideration depending on what the entity is. Now, you'll be glad to hear I'm on my 10th and final question, but that is, what are the other factors relevant to the overall fairness test? Now, as I said, if the financial difficulties test is satisfied in respect of the automatic unfair dismissal complaints, the tribunal still has to consider certain mandatory considerations in relation to unfairness or fairness, whether it is unfair or fair. Similarly, with non-restricted variations, they also have to consider certain aspects in respect of whether the dismissal was fair or not under section 98(4). Now, those considerations overlap, but slightly differ in respect of one way. So in relation to restricted variations, so section 104I and in relation to outsourcing K, a tribunal has to consider the nature of consultation and the incentives offered for the variation or change. For non-restricted variations, those two things are considered as well, but so too is the reason for the variation. So those factual considerations, what happened on the ground, are going to be important, because if you satisfy the financial difficulty defence in respect of the automatic unfair dismissal complaints, these factors will be considered. Or if it's a non-restricted variation, these factors again will be considered under the ordinary unfair dismissal regime. So that was a whistle-stop tour on some 10 key practical questions I think could be helpful to consider when looking at these provisions. And I'm now going to hand back over to Dan to discuss unilateral variation clauses.
Thanks, Sophie. Hello, I am back again. What I'll do though is I'll answer a question first of all, if that's okay, for two reasons. Firstly, I got quite excited when I saw there's actually a separate Q&A section in Teams. First time I'd realised that, and I saw there was a question in there, and in fact, it relates to something that Sophie was talking about. As I say, you can ask questions at the end, but I thought seeing as this one had popped up and it relates to the section that you've just heard, I would deal with it. I won't name names in terms of who asked the question. I'll just read the question out. And it says this: if the employer imposes a variation but does not actually fire the employee for refusal to accept a restricted variation, then would the employee be able to stand and sue relying on a hog dismissal with reference to, say, Section 104I, rather than having to take the risk of resigning and claiming constructive unfair dismissal? I would imagine that would be a lot easier for the employee to do and hard for the employer to defend. And the answer to that is simply yes, because dismissal, there is no self-contained definition of dismissal for the purposes of Section 104I, J, and K. So what we have to assume is that if once these new three sections are transplanted into Part 10 of the Employment Rights Act, that the definition of dismissal comes from Section 95 of the Employment Rights Act, and it's the categories of dismissal that we're familiar with. So express dismissal, constructive dismissal, I guess also expiry of a fixed-term contract, but also the Hog and Dover college style dismissal. So yes, there would be questions outstanding as to whether there has been a sufficiently fundamental change to the contract in order to justify the finding of a Hog and Dover college style dismissal. But yes, in theory at least, the employee can do that, of course. And this kind of brings me neatly onto the final topic that I'll be talking about. If the employer in that case has validly exercised a unilateral variation clause, that doesn't involve a breach of contract at all, and the Hog and Dover college style dismissal argument falls away. So the basic proposition for this part of the session is this: can the proper exercise of a valid, and I double underline the word valid, unilateral variation clause and allow an employer to sidestep the whole of the new regime? And as we've heard from Tim and Sophie, the starting point for this bit of the discussion is that baked into each of the new automatically unfair reasons is the need for the employee to fail to agree to the proposed contractual variation, which then results in termination of the employment of some description, whether that be express, constructive, or a hog dismissal. So all of that does beg this question: do any of the prescribed reasons apply if the employee's agreement to the variation is not required to bring about the contractual change? And my view is that those reasons do not apply. Now, before I say why, I think that the usual health warning: I'm not giving advice, so please make up your own minds as to whether you agree with this point. And if a court or tribunal disagrees in the future, don't call me up to complain, because I'm afraid I'm not offering refunds in relation to this seminar. But let me explain why I've come to that conclusion. And I've essentially got three reasons, so perhaps sharpen your pencils, because these are the points which are arguably the most important from this bit of my part of the seminar. So firstly, there is nothing within the reforms to suggest that they are designed to limit or cut down an employer's pre-existing rights under the contract. So to put it another way, these provisions don't override the contract. And so the effect of these provisions can't be to confer on employees a right of veto over contractual changes where no such right exists under the contract. The second reason concerns Section 104I(5)(h), which Sophie looked at, and which includes within the definition of restricted variation the introduction of a unilateral variation clause. So the purpose of that provision is to prevent, or at the very least restrict, employers from nullifying these new provisions through introducing unilateral variation clauses into individual contracts of employment. Now, this appears to me to be at least tacit acknowledgement that pre-existing, i.e. pre-Jan 27, unilateral variation clauses may have that effect, that they may nullify these new provisions. My third reason is this: that where an employer can validly implement a contractual change through its exercise of a unilateral variation clause, a necessary condition for the operation of the provisions, so the employee's dismissal, is unlikely to materialise. So where the employer utilises a unilateral variation clause to bring about a contractual change, the contract doesn't terminate, and there's no dismissal. There's no need for the employer to bring the contract to an end. Similarly, the employee can't resign in response to the proposed contractual change and claim constructive dismissal, because a contractual change authorised by a unilateral variation clause doesn't involve a breach of contract at all, which is something that Tim briefly touched upon in his section. Now, I suspect some, if not many of you, will all be sat there thinking, well, aren't unilateral variation clauses not worth the paper they're written on, because courts construe them in a way that renders them impotent? And this is where I perhaps take a slightly bolder view of the authorities and the received wisdom that is often set out within some of the legal commentary. Because, yes, it's true to say that the court's approach to unilateral variation clauses is probably best described as healthy judicial scepticism. And the position was perhaps best summed up by Lord Wolfe in the Wandsworth, Counsel and De Silva case. And I'll just read out the key paragraph in that judgment and what I think is important that comes from it. So there, Lord Wolfe said this: the general position is that contracts of employment can only be varied by agreement. However, in the employment field, an employer, or for that matter, an employee, can reserve the ability to change a particular aspect of the contract unilaterally by notifying the other party as part of the contract that this is the situation. However, clear language is required to reserve to one party an unusual power of this sort. In addition, the court is unlikely to favour an interpretation which does more than enable a party to vary contractual provisions with which that party is required to comply. To apply a power of unilateral variation to the rights which an employee is given could produce an unreasonable result, and the courts, in construing a contract of employment, will seek to avoid such a result. Now, the part of that quote that I find most interesting, certainly for these purposes, is that the court's power to intervene or to police unilateral variation clauses is limited to the construction of the clause. So it's not like a penalty clause where the clause, or indeed an unreasonable restrictive covenant, for example, where the clause will be struck down in its entirety if it's contrary to public policy. And of course, applying ordinary contractual principles, construction as an exercise is only required in the event of resolving an ambiguity of some sort in the written word of the contract. The other thing to be alert to is that even where the employer has an effective right to vary, that power is still subject to implied limits, so it must be exercised for a proper purpose, rationally, and in a manner that doesn't undermine the relationship of trust and confidence. And those are principles which are derived from, amongst other places, the judgment in United Bank and ACTA. So that brings me on to Bateman and Asda, and it's probably the one case on variation clauses that every employment lawyer knows, because it's arguably the high watermark of an employer's ability to use a unilateral variation clause to effect changes to terms and conditions of employment, and also, one has to concede, is a fairly rare example of a judicial endorsement of an employer's use of such a clause. It's helpful, I think, to just have a look at the clause in question, so the variation clause which Asda had in that case. And it said this, that the company reserves the right to review, revise, amend, or replace the content of this handbook and introduce new policies from time to time to reflect the changing needs of the business and to comply with the new legislation. A copy of the handbook is displayed on the colleague communication board in your store and on Pipeline, which I'm assuming was some kind of internal HR management system. And replacement copies are available from your people managers. I mean, just pausing there, nothing earth-shattering in the way in which that clause is drafted. Not particularly long, and also pretty vanilla in terms of what it says. And on appeal against the Employment Tribunal's decision that the contract authorised Asda to amend the contract without the employee's agreement, the EAT upheld the employment tribunal's construction of the contract and dismissed the appeal. Now, commentary on Bateman often urges caution in treating the decision as authority for the proposition that an employer can effect contractual changes through the exercise of a unilateral variation clause. And generally, there are three reasons for saying that if you have a dig through some of the commentary. Firstly, there was extensive consultation by ASDA prior to the implementation of the change. Fair enough, there was. Secondly, the change wasn't to the overall financial detriment of the employees. Not strictly true, but broadly speaking, was true. I think there were some employees who were worse off, but that tended to be the minority. And thirdly, the employees were prevented from arguing on appeal that the change involved a breach of the trust and confidence term on the ground that the argument hadn't been pursued before the employment tribunal. So basically, bad luck, you didn't argue it below, therefore you can't argue it on appeal. And to this extent, I agree that Bateman shouldn't be elevated to a general endorsement of unilateral variation clauses because, without wishing to state the obvious, the decision concerned the specific clause in issue set within the specific contract and the specific relationship between the parties, and a different clause in a different context may lead to a different result. But if you read the judgment in Bateman, it seems to me at least arguable, indeed highly arguable, that those three things, so consultation, a lack of detriment, trust and confidence, wouldn't have changed the outcome on appeal because, as is apparent from the judgment, if you read it, and the paragraphs I'd invite you to have a look at if you have a reason to look at this issue, it's paragraphs 27 through to 32. The appeal was determined on an issue of pure contractual construction. So coming back to the point I was making earlier. So effectively, the clause meant what it said and authorised ASDA to make the contractual changes that were the subject of challenge. So just squaring the circle by posing this question, are unilateral variation clauses the great antidote for the employer to these reforms? Well, I think you know what I think, potentially, but I will leave you to judge that for yourselves. But I will finish by making these 2 points, in case you're going to rush out and advise all of your employer clients to introduce or amend unilateral variation clauses in the near future. First thing to say is the window of opportunity is closing for any employer who wants to introduce the unilateral variation clause or amend or tighten up an existing variation clause, because you've only got until January of 2027 to do that. So what are we saying, 6 months, give or take, before these reforms come into force, assuming the timetable remains as it is. As we know, this was pushed back, I think, from October of this year is pushed back to January of 2027 to allow for a delayed consultation exercise. And of course, trying to introduce the unilateral variation clause after January of 2027 will be all the harder because that falls within its own category of restricted variation, as Sophie has discussed. And secondly, if employers are thinking of changing contracts to introduce variation clauses, then they need to give some thought as to how they will evidence consent to the change. And here you run into some of the old problems, albeit still within a more relaxed regime. It will become a hell of a lot less relaxed from January of 2027. So when it comes to collective changes to terms and conditions, we have the same traps that Tim has covered when looking at the existing law, which I won't repeat. And if the employer chooses to go down the path of unilateral implementation, i.e. just sticking the change into the contract and seeing what happens, then of course the important question there is from where do you infer the employee's agreement to the change? Because employee inaction, i.e. them doing nothing, them saying nothing, in the face of a new term isn't enough to evidence consent if the term doesn't bear upon the employee's position at that time. So a classic example of that is a change to redundancy terms that's implemented unilaterally without a variation clause. The fact that the employee doesn't complain about it at the time doesn't mean they've consented to it on the basis that of course, at that point in time, they weren't redundant. And have a look at the case of, or the EAT's decision in Selectron on ROPA, which deals with that particular point. So something to chew on, I think, in relation to unilateral variation clauses, and potentially something which may strengthen the employer's position if they have a well-drafted clause within the contract. So with that bit of discussion, that brings the three of us to the end of this session, certainly to the end of this session, or the part of the session at which we speak to you. There is the opportunity to ask questions. There is, I think the way it works, just looking at Teams or the way it's presented to me on my screen at least, there is a chat function, but there is also a Q&A function. Oh, here we go. Oh, I should have refreshed it, shouldn't I? Because now there's loads of questions in there, whereas before there was only one. Right, let me go through them, because I can see people have already been asking. So, yes. So, one question. I'm assuming my colleagues Tim and Sophie can see these as well. So if they want to answer any of them, feel free. But first one is there still scope post 2027 to include unilateral variation clauses in contracts for new staff where dismissal isn't likely to be an issue and employees are more likely to agree? Answer to that, yes, absolutely. Because if you're presenting new terms, it's for the employee to agree or not. And as is almost universally the case, say for very senior hires, employees sign on the dotted line and they are deemed to be bound by the contents of that contract. So I think the answer to that is a very clear yes. Next one. The next one is the same question. That makes it easy, doesn't it? Effectively the same question. Can UVCs be included in brand new contracts anytime after Jan 27 because it's not then a variation contract? Yes, that is, albeit expressed differently, the same point. So what have you got next? So it says in the context of corporate transactions, we often suggest dismissing and re-engaging key employees in order to get them onto new restrictive covenants. We understand that this practice can continue going forward. Are we correct? I think that's right. If Tim or Sophie have a different view as to this, let me know. So, as Sophie touched upon, restricted variations. Well, it would be a non-restricted variation, wouldn't it? I'm going to pass over. I'm going to pass over to Sophie rather than steal her thunder in relation to this.
I would think that
it would be a non-restricted variation.
Yes, so I anticipate it wouldn't be an automatic unfair dismissal, but then the heightened considerations in terms of the fairness considerations in J5 in relation to the reason consultation will apply because it's a restricted variation. So I think it would apply in that context. It wouldn't be a non-restricted. I don't think it fits anything in subsection 5 A to H. But I think it would be non-restricted.
Yeah. So as a broad rule of thumb, and I'm not saying this is a perfect summary, but restricted variations concern pay, hours, and holidays in broad terms, which is why you don't have things like duties and place of work included within the notion of a restricted variation, or at least not presently. Whether that changes in the future following consultation remains to be seen. But restricted covenants wouldn't fall within that description, but it would be a non-restricted variation, and those additional factors that Sophie's just described would apply when it comes to assessing the fairness of a dismissal, assuming a dismissal flows off the back of that attempt to change the contract.
Yes, because I think it would satisfy the subsection 3 rather than the 2 in terms of the dismissal was to re-engage them under a varied contract to carry out the same duties or substantially the same duties prior to dismissal, because all that's being changed is the restrictive covenants. So I think it would fall within probably J subsection 3.
Yeah.
I've seen then that in relation to the chat, there was a question about a reduction in generous sick pay policy and whether that would fall within the scope, I'm assuming, of restricted variation, subsection 5A. I think the question there for me would be whether it was a contractual sick pay, so therefore a term of condition of employment, as opposed to a non-contractual policy. Because, as I said, that's whether it would bite or not. But if it was a contractual aspect, then I anticipate it would fall within the concept of an entitlement to a sum payable in connection with employment, is my view on that, I think.
Yeah. Oh my God, there's loads of questions now. I'm not sure we're going to be able to get through all of these. Let's try and do them in reverse. I might pass over to you, Tim, for the first one. Can you see the top one where it says, even if there is an automatic unfair dismissal, is compensation likely to be limited, provided there's been full and proper consultation? Because I know, Tim, you were discussing the other day about how a lot of these factors to reasonableness might feed into a mitigation type argument, and actually the old arguments that we might trot out on an ordinary unfair dismissal in a dismissal and re-engagement exercise might now feed into the amount of compensation as opposed to the fairness of dismissal.
Yeah, I mean, I think that's absolutely right. I think when it comes to compensation, obviously the amount and extent of consultation that you've conducted, well, ultimately that's going to be relevant where you're talking about non-restrictive variations. Ultimately, that's going to be relevant to fairness. But I think when it comes to mitigation, as I said, the point is, has the employee unreasonably failed to mitigate their losses? And the argument we want to run when we're acting for employers is that yes, they have, because there was an offer on the table that was perfectly good and they should have taken it and they didn't take it. Now, if you have run an extensive consultation, if you have compromised, if you have made changes to address concerns, if you're given reassurances, all of those are going to be taken into account. And ultimately, I think if the tribunal says, yeah, that was a reasonable variation or reasonable offer of re-employment, and the employee didn't take it, was unreasonable for them not to have taken it, their compensation is going to be substantially reduced. And indeed, it follows, I think, that it has to be reduced to zero because the failure to mitigate is immediate. But no amount of consultation, I think, is going to affect the compensation when it comes to a reasonable refusal. So if you're talking about a substantial change, and if the tribunal says, yeah, it was reasonable for that employee not to have accepted that contractual variation, then I don't see how it makes any difference how much consultation you've conducted or the employer's conducted when it comes to the fairness of that, when it comes to the award the employee is entitled to. Because as I said, I can't see how a tribunal can reach a conclusion that was unreasonable for an employee not to have taken accepted a variation to the contract that was in itself unreasonable.
No, that's good. Thank you, Tim. I'm conscious we are beyond the allotted hour, so it's now 1:33. I can see some people logged off already, and I'm also conscious that we're eating into people's lunch breaks, or perhaps even shortened lunch breaks. Apologies, we've not got through all the questions. There were several hundred of you logged in, and we probably could have been here all afternoon answering questions if we'd gone through them all. What I would urge you all to do, if you do have a burning question, just feel free to email one of us. I don't think anybody or any of us three would object to you sending in whatever question you've got, and we will do our best to help you out with it. So feel free to do that. But I think that brings us to the end of the session. Thank you, everyone, and there's been quite a few of you in the end who have joined us to listen to what we've got to say, and hopefully we will see you again the next time. Thanks a lot, and have a good afternoon.
Thanks very much.
Thank you.
This podcast was brought to you by Littleton Chambers. For more information on our barristers and clerks, please visit littletonchambers.co.uk.